going to discuss and learn about important judgment delivered by an Honorable Supreme Court. It is the latest 2026 judgment, which comes by the name of Bernard Lyngdoh Phawa versus State of Meghalaya. So basically this case talks about the circumstantial evidence. This case is entirely based on circumstantial evidence, as in this case there was no direct evidence was available to prove the guilt of the accused, which is the case in many criminal cases. So we will be dealing in this case. What has happened was, firstly, this case is the judgment was delivered by a 2-judge bench, and this is decided on 27th of January 2026. So moving further, the case, the trial court has acquitted the accused. Trial court has acquitted the accused due to lack of that there was many evidences, but due to lack of completion of chain of circumstantial evidence, the trial court has acquitted the accused. Is not sufficient to enter a finding of guilt, resulting in the acquittal of the. Thereafter, what has happened is the High Court reversed the acquittal, and convicted the accused. Now, by way of the present SLP, the accused was before the Supreme Court seeking reversal of the aggrieved by the High Court order. So basically this case, in this case we will basically discuss 3 points. Firstly, circumstantial evidence, whether chain was complete or not, as was delivered by as the law has been laid in the case of Surat Birdhichand Sarda. Secondly, with respect to the confessional statement, what is the validity of the confessional statement given by the accused. So basically these two are the main point, and while doing so, we will be dealing with the various relevant facts which have been considered by the Supreme Court. So firstly, now without making delay, let's go look at the facts of the case. So the fact was that the case begins with the missing person complaint. A person went missing, and regarding them a complaint has been made, and which led to the arrest of the co-accused persons. Thereafter body was discovered. That was discovered from the graveyard. Thereafter the recovery of rope. This is the recovery of rope. Rope was the primary weapon which has been used in the killing of the while strangulating the victim. So thereafter various relevant fact is there, that is the allegation of ransom calls received, recovery of material possession of the victim from the house of one of the co-accused, and a mobile phone was also recovered from one of the deceased, which was later recovered from a witness. So we will be dealing what are the relevant facts which have been which we will be dealing with the relevant facts which have been come before this case, before the court. Firstly is the last seen together theory. Secondly, confessional statement is there. Thereafter, recovery of body. Ransom calls. Thereafter, regarding the post-mortem report, that is time of death. And with respect to this post-mortem report, that is the medical evidence is there. Doctor must have been examined. Recovery of body, confessional statement 2, 3, 4, 5, 6. Recovery of rope, which was allegedly the weapon used in the present case to strangulate the victim. Then there was the recovery of certain articles like laptop, mobile, etc. So we will be dealing with each points how the Supreme Court has dealt. Confessional statement that we already dealt. Ransom call is there, which will go on to suggest the motive. So these are all the circumstantial evidence. So whenever a case comes before the court, so by these all things, the chain is to be completed. Even if the chain went missing, then the burden is on the prosecution to prove its case. Thereafter, the defense will enter into the picture and will prove its case. So basically, first the prosecution has to prove all these points beyond reasonable doubt. That is, in the present case, last seen together, confessional statement, recovery of body, ransom calls, time of death, recovery of rope, recovery of articles. So these things have to be proved. Like, these things should go on to suggest that it is the accused persons only who have committed the offense. So we will be dealing with each and every point by point. So firstly, starting with last seen together theory. So on the point of last seen together, what the Supreme Court has observed that in para 13 onwards, that there was no proof. Supreme Court held that there was no proof that deceased was seen immediately before the death with the accused. With respect to the to prove this fact, that is the last seen together, various evidences was laid, that is the witnesses was called upon. So with respect to the PW1, the court held that it is a hearsay. With respect to the PW6, court held that he only said that victim had planned to meet a accused one. And with respect to PW12, which is the auto driver, the court held that his identification is doubtful. So with respect to the this point last seen together, there is para 13. Last seen together we cannot notice, but there is no proof of the deceased having last seen together with the accused immediately before the death occurred. So this is with respect to the last seen together. PW6 is there. His statement was refuted by the Supreme Court by saying that the PwC reported that she was a close friend of the deceased and they did projects together, for which reason the laptop of the deceased was entrusted to PwC. It was the statement of the day that it had rung up in the course of the day to tell her that he will be collecting the laptop later, and also that he would be meeting A1 in the evening. This point is important. This is not in proof of the victim having seen with the accused in the evening. So this point only says that the victim had has been planning to meet accused number 1, but in no way it is saying that the Supreme Court went on to this point exactly, and with respect to PW6 it has been refuted. And with respect to the auto driver, it has been stated that his identification is doubtful. Nothing to indicate how A1 was identified as having traveled into the rickshaw on the fateful day. So his identification was doubtful. Now moving further, with respect to the TIP, the Supreme Court also held that it was also stated that there was no other person standing with the accused at the time of identification. Hence, there was no TIP carried out as is required in the course of investigation, which in any case only lends credence to the line of the investigation. So TIP was also refuted. So with respect to the last sin together, Supreme Court refused to accept this point. Now second was regarding the time of the death. The Supreme Court held that the death could have occurred. It is the Supreme Court observation that death could have occurred any time before 20th February. And with respect to this, the Supreme Court has, with respect to the medical evidence, it was observed that there is a hyoid bone intact, which goes on to suggest a possible hanging. That is, the accused died by hanging. And there was no typical strangulation sign. That is, the accused have strangulated the victim. So here two possibilities are there. That is, there must be a possibility of suicide cannot be ruled out. So for this we will going to para 10 and 12. Regarding the time of the death, the postmortem conducted on Nitna found date occurred prior to 2 days, that is prior to 48 hours. The deceased was missing from 18 February and the body was recovered. Death could have occurred any time before this date. A2, in the cross-examination by A2, it was categorically stated by the doctor that the hyoid bone was found broken at both sides, which could happen in a strangulation suspending the body, that is by hanging. It was also opined that it could be a case of suicide by hanging. So whenever the possibility comes, here there is two possibilities there. Especially since the larynx of the deceased was found intact and not broken, which could happen in a case of strangulation. The doctor went further to say that there was no blood clot in the nostrils, ears or mouth, so and so, which are again common symptoms of strangulation. Hence the medical evidence is not conclusive. So this is the important line. The medical evidence is not conclusive as to a homicide, but the fact remains that even if the death was by hanging, the body was exhumed from where it was buried. So this is important. Even though, let's say, the medical evidence was not conclusive, but other relevant fact was there. If the prosecution was able to prove these facts, then the medical evidence would have become the conclusive proof. Because in this case, in the criminal case, you have to complete the chain. and you will complete the chain while this is the medical evidence is there, this is the recovery, this is the confessional statement, then there is the recovery of articles like laptop, then last in together theory. These all will go on to prove the chain of evidence complete. There will be a complete chain of evidence. So now with respect to the medical evidence and time of death, this is also been refuted by the Supreme Court. So we have done last in together, we have done time of death. Now with respect to the recovery of dead body, we will be directly referring to para 17, where the Supreme Court has specifically stated that there was no statement. This was basically related to section 27 of the Evidence Act. So with respect to this, the Supreme Court observed that there was, because for section 27 to apply confessional for recovery, regarding the recovery statement, there was no statement which recorded that it was the accused which led the police to graveyard, and it is a very important point for section 27. So doc identification has to be there. If no, then recovery statement, recovery of dead body is of no relevance against the accused. So this was the point, and it will be directly can be found there in para 27. Now moving further, this was also refuted. Recovery of rope, that is the alleged weapon which was used. With respect to this, the Supreme Court has said that the rope was recovered from an open place, and there can be no denial that since it was recovered from a open place, it has no evidentiary value because it can be compromised. No evidentiary value. Here also section 27 fails. Now moving further, with respect to the recovery of articles, para 20 to 22 is there, and in this one of the witnesses went hostile. So this is not the main relevant fact, but also there is no proof that articles belong to the deceased. So this was one of the points which the court have considered, belong to the deceased. Now moving further, respect to the confessional statement, this is one of the important points. Now we will deal with respect to this. We will be directly going to section 23, para 23. The learned counsel appearing for the state has specifically urged that the confession made by the two co-accused. So here there is a 2 point has to be noted. There is two accused, A1 and A2. A1 says that the A1 confession is exculpatory. Exculpatory means it is A1 is basically saying that he is blaming A2, that A2 has committed the murder. And what A2 is saying? A2 is saying he does not commit murder. He does not commit murder. Rather, he only says that victim took the last breath. So this can no way, so this statement of the A2 can no way be said to be a confessional statement with respect to the direct admission of his guilt. Direct admission of guilt. This is in no way. So, and as we know that for a confession, it must be voluntary made statement. It must be true, and it must be a direct admission of guilt. In here, the direct admission of guilt point is missing. Further, there is no corroboration. There is no corroboration of the confessional statement. Confessional statement lacks corroboration. So, this is the point. The confession so made is exculpatory in nature and clearly incriminates the co-accused. Further, here the Supreme Court is saying that a confession has to be a direct acknowledgement of the guilt of the offence in question, and such would be sufficient by itself for conviction. If it falls short of such plenary acknowledgement of guilt, it would not be a confession, even though the same is of some incriminating fact which taken the other evidence tends to prove his guilt. So this is the important point. So further, the confession allegedly made by the plaintiff is of no use in bringing home a conviction, especially when there was no corroboration available of the statement made from other valid evidence. So, okay, firstly, the Supreme Court is refuting the confession part, and even though if for a moment if we agree by the confession, it is not being corroborated by other evidences. So on this point also the case of the prosecution fails. So till now we have discussed the points like circumstantial evidence, relevant facts, last and together fails, confessional statement fails, recovery of bodies fails, time of death fails, recovery of rope fails, recovery of articles fails. Now with respect to the ransom calls, what the Supreme Court is saying that with respect to the ransom call, the court has discussed in para 16. We will be referring to para 16. So basically on ransom calls, the court is saying that this point has not been investigated. This point has not been investigated properly by the police. And even though it has no link to the accused to the ransom call, and witnesses are unreliable. These are the 3 points. Witnesses are unreliable. So these are the points. So we will be reading PW5. The father of the victim deposed about 2 phone calls in his mobile number demanding ransom, which the police did not follow up in their investigation. So this is directly a defect in the investigation. PW1 and PW1 classmate and friend of the spoke of their visit to so and so. This does not in any manner prove the ransom calls alleged to have been made by 2 PW5 co-owner who did speak of some person having come to his PCO on so and so date, and the same person having requested him the next day to not disclose their identity. But the witness categorically stated that he would not recognize them if he met them again. The ransom call hence remained an unsolved puzzle. So ransom call point has not been investigated properly. So basically, after analyzing all this, the Supreme Court went on to say in para 31-32, having discussed this is how the case proceeds. In every case, there is a relevant facts. There are many relevant facts. Like in the present case, there was last seen together. There was recovery of body, recovery of rope, recovery of articles like laptop, mobile phone. Then there was confessional statement. Then there was what was the other points that we discussed? Time of the date, that is medical evidence was there. So these was the point, like if prosecution was able to prove all these points, then chain would be complete, and the prosecution and conviction must have been upheld. But since the chain was missing, and in the criminal case the burden is of proof beyond reasonable doubt, so on that point the court reversed the acquittal of the High Court, reversed the order passed by the High Court, and reversed the conviction order passed by the High Court, and acquitted the accused. So we'll be reading para 31. Having discussed the evidence, we fail to see any circumstances having been found from the evidence laid in the prosecution before the trial court to arrive at a hypothesis of the guilt. The High Court proceeded on the premise that the trial court lost its way on the minor details and failed to see the larger picture, which was obviously and eventually admitted in the confessional statement. The admission were only that made in the confessional statement of the death having occurred in the presence of the accused. So here the main part with respect to confessional statement, the court is saying that the accused is not admitting the direct guilt. Accused is not saying that I have committed the murder. He is only saying that the victim took the last breath in my lap. So this in no way is admission of the guilt. So death having occurred in the presence of on the day the deceased was found missing, which we have found to be not worthy of acceptance. We find absolutely no reason to uphold the conviction of the accused as entered into by the High Court, reversing the order of the acquittal of the accused with the trial court. We reverse the order of the High Court and restore the trial court order which acquitted the accused. So this was the issue, and so thank you.